Afternoon. Committee on Judiciary and Hawaiian Affairs is called to order. It's Tuesday, February 9th at 2 p.m. Video via video conference in room 325. There you go. Okay. First up is House Bill 884, relating to the Office of Information Practices. First up, we have Sheriff Wakazu Park, Office of Information Practices.
Thank you, Chair, and members of the committee. OIP supports this bill, which would require it to resolve open meeting and open record complaints through either a written opinion or informal guidance, and offers a proposed amendment to clarify that the guidance must be in writing. In the 2019 legislative session, House Resolution number 105 requested that OIP conduct an experiment by offering quick informal guidance on some appeals to see whether that would be sufficient to resolve the requester's concerns while processing other appeals in its normal manner. As a result of the experiment, OIP concluded that offering written guidance in the form of inclinations was sufficient to close some appeals, but in most cases, no time was saved as the requester exercised their right to insist upon an opinion even after receiving OIP's written inclination. Rather than leaving it to the requester to determine how a case should be resolved, it would have been far more effective if OIP had the statutory discretion to decide whether to provide an opinion or written informal guidance. This particular provision of the law does not give OIP such discretion and requires OIP to make a full legal determination unless the requester agrees that the matter has been resolved by OIP's written guidance. And we understand that opinions are important and necessary in some appeals where they are needed to require an agency to disclose records or to take specific action, or an important unsettled legal issue must be decided. But in many other appeals, OIP believes that informal written guidance would be much more suitable, less time consuming, and more efficient in reaching the same result sooner. This bill would give OIP much needed flexibility to handle its growing caseload and to improve its efficiency within the constraints of its diminishing resources. It would not prevent any member of the public from making a complaint to OIP under the UIP or Sunshine Law, and it would leave in place the requirement for OIP to review such complaints. But whether OIP issues an opinion or an informal written guidance, a requester always has the right to go to court for relief and need not exhaust administrative remedies or wait for an OIP opinion to do so. OIP would still be able to issue opinions when needed to get agencies to disclose records, but the bill gives OIP the much needed flexibility to resolve a complaint either by writing an opinion or offering informal guidance as is appropriate. I'll be happy to answer any questions that you may have. Thank you.
Thank you very much. Next, we have R. Brian Black, Civil Beat Law Center.
Good afternoon, Chair, Vice Chair, members of the committee. It's Brian Black, Executive Director of Civil Beat Law Center for the Public Interest, testifying in opposition to the bill. When members of the public go to OIP with a complaint, they're not looking for advice. OIP isn't Dear Abby. They're looking for a resolution of a complaint and a determination as to whether or not there's a violation. The core purpose when OIP was set up was to resolve these kind of complaints, to provide an informal, where you didn't have to pay legal fees and you didn't have to pay a filing fee to go to court to get an actual resolution. And the idea that you would turn this around and make it such that it's just a place where you can go to get advice especially when the OIP can already do that, it's taking away the entire benefit of the office as it was originally set up. I'm happy to answer questions. Thank you.
Hey, thank you very much. That's all the testimony we have for this particular bill. Members, any questions? Representative.
Thank you, Chair. Mr. Black, do you have any bolt scores in terms of the OIP decisions, in terms of how many are actually substantive, yes or no, versus guidance? You said this one is eviscerating what they do, but what's the score look like so far in their decisions?
I mean, their decisions right now are they're required to provide a decision. So they're required when their opinions or in their informal decisions to say whether or not there's been a violation. So what this would do is make it so that they don't have to resolve the disputes between the agencies and the parties. It's just advice.
But you said they can do this already. My question is, have they done it? And if so, what percentage of the time are they just giving you advice so we don't need the bill?
Oh, so they have other, not when you file a complaint. So they have attorney of the day services. They have guidance that they provide in other contexts that are not appeals and complaints. Appeals and complaints is what they're trying to modify now. So they have other provisions in their authorizing statute that allow them to provide guidance when there are requests.
So they haven't used what you said they could use them.
They do provide attorney of the day services, for example. So they do have a service whereby you can contact them, a member of the public or an agency can contact them and ask, so what do you think about this particular issue? And they will provide informal guidance.
So if the bill passes, what is the harm if they're already doing it and this says you can now do it legally versus you can already do it legally? Or what would be your opposition?
So the opposition is that when someone actually files a complaint, as opposed to going to them and asking for attorney of the day service, when someone files a complaint because they're not getting what they want, either as a public record or they think that the board has violated the Sunshine Law, the open meetings law, at that point, that person is asking for an actual determination from OIP as to was there a violation or not. And what this bill would do is allow OIP to, through its normal course, which is currently backlogged several years, determine at the end of all of that, when the member of the public has been waiting, determine at the end of that they're not going to issue a determination as to whether or not there's been a violation. Instead, they're going to issue some sort of guidance or advice. And then the person can go to court and try and figure out whether or not there's actually been a violation. There's no reason for that. There should be an actual determination from OIP. That's the whole purpose for OIP.
Okay, so you're saying they are not now providing guidance and advice. They're just backlogging it and doing nothing, or let's say stuffing it back in the queue.
So they do multiple things, right? For complaints and appeals, they provide determinations. For attorney of the day advice, they provide advice. Right now, when someone files a complaint with OIP, which is a formal complaint, goes through a formal process, at the end of that, what OIP does is issues an opinion or a decision. And that opinion or decision resolves the complaint with the agency. Was there a violation of the public records law? Was there a violation of the Sunshine Law? So that's one thing that they're doing. At the same time, they're also providing informal guidance through pamphlets, through attorney of the day advice, and other things, which is helpful, and that's authorized by their statute. But what this bill changes is the appeal and complaint process, and says that there does not need to be a ruling, a determination on that appeal or complaint, that formal complaint. They can do instead just guidance.
Okay, highly nuanced. Thank you, Chair.
Members, any other questions? Okay, seeing none, we will move on to House Bill 659 relating to forfeiture. First, we have Michael Vincent, Deputy Attorney General. Jason Redula, DLNR.
Good afternoon, Chair and committee members. Jason Redula, DLNR's Enforcement Chief for the department. Department will stand on its written testimony in opposition of this measure. Thank you.
Thank you very much. V.S. Hayakawa, Department of the Office of the Public Defender.
Hi, good afternoon, Chair Nakashima, Vice Chair Matayoshi, members of the committee. I am Assistant Public Defender Lee Hayakawa. The Office of the Public Defender will stand on its written testimony. I am available for any questions.
Thank you very much. Next. Trisha Nakamatsu, Deputy Prosecuting Attorney.
Thank you, Chair, Vice Chair, members of the committee, Deputy Prosecutor Trisha Nakamatsu, appearing on behalf of the Honolulu Prosecuting Attorney's Office. We are opposed to this bill. You have our written testimony before you. I just wanted to quickly point out that the number one concern we have is that there seems to be a serious misunderstanding between between the fact that there's two completely separate tracks of law, is the civil and the criminal, and yet this bill attempts to conflate the two. It's trying to apply a criminal standard to civil proceedings, just like when one infamous case, say the O.J. Simpson case, there was criminal proceedings, lost on that, civil proceedings, totally separate, had nothing, in a sense, to do with what happened in the criminal proceedings, and that one they prevailed because there's completely different standards, different rules applied by the court. Similarly here, although it may seem unusual that the prosecutor's office is involved or participating in a proceeding that is civil, we are in that instance just acting in a civil capacity. It's not as criminal prosecutors, we're not adhering to the criminal standards. We're solely using the civil standards that exist now. We would like to emphasize that there is due process in the civil asset forfeiture procedures. There's set procedures, rules, standards, and the Department of Attorney General has, we believe, already met nearly all of the recommendations made by the state auditor in 2018, and they are actively working on the final recommendation. The concern from citizens, at least from what we've heard during the hearings, appears, well, aside from the misunderstanding between there being a civil and criminal proceedings, which travel in parallel and are not related necessarily, is that the process is so onerous, it's confusing, it's inaccessible, and those things we feel that if those are certainly understandable concerns and problems, and the details of the system might have to be looked at and what the procedures are. Should there really be bonds and all kinds of other things required? Should more notice be given, more transparency? Hopefully a lot of the AG's changes have addressed many of those concerns, but they haven't really had a chance to take hold and to play out to see how much better they work now that those systems are in play. We would like to emphasize, going back to the civil and the criminal differences, that there are numerous bodies, dozens, in fact, of boards, commissions, civil courts that use preponderance of the evidence standard to essentially take away or withhold or deprive people of their property, their money, and, as we know, potentially their livelihoods, if you're talking about their professional licenses every day. So we just would like to emphasize that this should be no different. It is no different in that it is a civil standard, a civil proceeding. The fact that someone from our office participates in that proceeding shouldn't affect the way you perceive it. because it is in fact civil and it should remain that way. That's what allows the process to move up so much more quickly. That's what allows the contraband and things that have to do with this wrongdoing, keep it off the streets, and allows the program to be self-sustaining to the extent that it is, because they are able to move those things quickly before the materials deteriorate or before years have gone by with it just sitting idle in storage. We're available for questions, if any. Thank you for the opportunity to testify.
Thank you very much.
There's my note.
Next, we have Philip Johnson, Honolulu Police Department.
Yes, Chair. The Honolulu Police Department stands in opposition. You have our written, and I'd be available for questions if you have any.
Okay, thank you very much. Next, we have Wayne Tanaka, Office of Foreign Affairs.
Good afternoon, Chair, Vice Chair, members of the committee. Wayne Tanaka for the Office of Foreign Affairs. I'll just stand on our written comments and I'll be available for questions. Thank you.
Okay, thank you very much. And then Mandy Fernandez, ACLU of Hawaii.
Good afternoon, Chair, Vice Chair, members of the committee. Mandy Fernandez on behalf of the ACLU of Hawaii. We support this bill. Civil asset forfeiture is a civil action brought against a piece of property on the premise that this property is guilty of a crime. It became popular a few decades ago as part of the failed war on drugs. The entire purpose of civil asset forfeiture is supposed to be to disable criminal operations. Instead, it's become a way to pad the budgets of police and prosecutors with little oversight or accountability. Hawaii's asset forfeiture law is one of the worst in the nation. We have a low burden of proof. Hardly anyone gets to have their day in court before their property is forfeited or sold off by the state. And if they do go to court, it is at their own expense. We do not require that the crime is even tied to the property owner. We have weak protections for innocent property owners. And in fact, in 2018, a report by the state auditor found that over a quarter of all forfeitures were done where there were not even corresponding criminal charges in any case against anybody. This is often called policing for profit because law enforcement have a strong incentive to seize valuable property that is only tenuously connected to a suspected crime. Under Hawaii law, police get 25% of the proceeds, prosecutors get 25% of the proceeds, and then 50% go to the criminal forfeiture fund. This measure is necessary to protect innocent owners by requiring that forfeitures only go through the process after there's been a felony conviction. And it mitigates the profit incentive by directing all proceeds to the general fund. So police are only doing this because it will actually disable criminal operations and not because they'll profit from it. That being said, police will still be able to seize property. So they'd still be able to accomplish the objective of asset forfeiture by taking the property away and disabling criminal operations if they are happening. The state would just not be able to ultimately forfeit this property until there's been a conviction in corresponding case of the property owner. To end, I will note that more than half of the property seized in fiscal year 2019 to 2020 was cash. So that's not expensive to store pending criminal proceedings. Thank you.
Thank you very much. Members, that's the testimony that we have on this measure. Are there any questions? Representative Ford.
Thank you, Chair. Is HPD still on the line? Officer Johnson, we know that parking tickets don't go to the department itself. It goes to the general fund. This bill says that now all forfeiture will go to the general fund. As you all know, we have a big deficit. Do you guys have a problem with that? I know you're against the bill, but is that part of the bill of any difficulty to you?
That's actually part of it that we are strongly opposed to. I have a number of full-time staff that just works investigations involving forfeiture. In addition to the storage, yes, half of it is cash, but the other half are vehicles and property. that we have to store while it's adjudicated in the on the civil side. So yeah, we're opposed to that part of the bill as well.
So you would lose some staff, or at least wages of some of your staff there.
Investigative hours, wages. It's the investigation that goes to a forfeiture case is equal to what we put into a criminal case. It's seized on probable cause. It's investigated. It's all packaged up and then conferred with a prosecutor who screens it another time. That takes personnel hours, salary, sometimes overtime.
What about the charge that this was meant for the big fish, the big drug dealers, and now the small guy is getting pinched by this? Does that make sense? I'm not sure I understand it.
I didn't hear the first part of your question. I'm sorry.
The intent, well, the accusation was this was meant to stop drug dealers, the big fish, to halt them in what they're doing in drug dealing. But in effect, and I forget who the testifier was, said the small guy is getting pinched with this. Is that your
Sorry, I didn't mean to cut you off, but the intent is to stop crime and criminal activity. And we seize property that are proceeds of a crime or used in a crime. So whether it's a big fish or a small fish, we're just trying to stop crime.
Okay, then the last question, Chair, is how much money are we talking about? If we took all forfeiture and put it in a pile, how much money would that equal?
I don't know.
Well, the total asset forfeiture equals how much money per year?
I'm sorry, I don't know that answer.
Does anyone on the call know that? Because that has a lot to do with the big, huge budget deficit of the state of Hawaii. Does anyone know?
Representative, if I understand your question, you're asking about the total value of the property that was forfeited in the last reporting year. Is that correct?
Exactly. The total
right.
value.
$828,609.
So not quite $1 million. Okay, terrific. Thank you very much. Thank you, Chair.
May I pipe in?
Please add on to that, if you will.
Yeah, I'm sorry, I was muted. I was flustered. I couldn't get online, so I didn't realize I was muted. But the figures as far as what asset forfeiture brings in, and before I go on, I'm Gary Sinaga with the Department of Attorney General. Good afternoon. Thank you for letting me speak at this hearing. It's all published. It should be on the Attorney General's website. It gives figures as to the amounts that are seized, ultimately processed, and processed meaning it goes to the point where the AG orders forfeiture, and this is only on the civil side, is in the annual report. And I'm looking at the 2019-2020 annual report. The actual money spent, because that $800,000 figure, let me start by telling you that, is based on estimated values of hard property, not cash. And these are vehicles and other miscellaneous items that that figure is derived from the police department's rough estimation of what this car is worth, what this computer system's worth, what this camera's worth. But ultimately, they go to sale if there's an auction, and we get actual cash as a result. And the final figure for 2019-2020, as far as the amount of money that the forfeiture program generated, on page 8 of the report, and the criminal forfeiture fund, the amount of money that was deposited into the forfeiture fund was $354,013.
Sorry, repeat that again. I couldn't hear you.
$354,000.
354,000.
354,313.24. So in 2019-2020, forfeiture cases went down, unlike years past. And if I may, just to pipe in on the thing about the big fish, the intent of the forfeiture program was to get the big fish. And having seen these petitions come in, there are big fish in that part of that big pot. I mean, that amount of money. There's seizures of tens of thousands of dollars where guys are trafficking in pounds of meth, and there's some heroin now. And And when they get lucky, when they do the bust, there's cash. They find cash. Sometimes they're not lucky, and somehow the bad guy gets rid of the money or is hides it somewhere. But as far as little fish getting stung by this, it does happen. But these guys are still breaking the law. So if they use the money to facilitate, purchase, or sell drugs, it's fair game to seize to seek forfeiture for those funds. But also, what these small fish things entail could be the 26% that is not related to a charged offense. Someone brought up the fact that a quarter of the forfeiture cases did not relate to does not correspond to charges or convictions. Many forfeiture cases do end up not resulting in a conviction. I would say the vast majority, 99%, there are charges attached to it. Well, not 99%, but there a percentage, a high percentage. And the reason why there's a 26% puka, so to speak, is because many of these forfeiture cases end up in the bad guy working out some kind of arrangement with the police. And this is the small fish, and they're used to catch the big fish. They turn state as a confidential informant, or they participate in controlled buys, reverse buys. Some of these uncharged cases are cases where there is not uncharged, unconvicted cases are cases where there is a charge, but as we all know, it's a task to bring that charge to conviction, and along the way, there's courts get involved, and there's suppression of evidence, lost witnesses, and things like that. So, on paper, the property is forfeited, the person is charged, but there's no conviction. But on the civil side, where it's proceeding on a separate route, and there is opportunities for the owners to contest, it moves forward, and we do get the forfeiture because the standards are lower, but the standards are lower for both sides. Just as easy as the police needs to show that this property is connected to a crime, the innocent owner can easily convince or persuade the Attorney General's office that they are genuine innocent owner. They have no knowledge the property is being used for criminal activity. This is money that does not come from some illegal activity, but from some hard-earned job. It's hard-earned money from work or from an inheritance. And as in the report shows, there's easy. Last year had about 10 cases where the Attorney General looked at petitions for mitigation and remission, and there was resolution. It was either granted in part or in whole. So the innocent owner is given back the property. So there are safeguards in the law itself. So that that's all I have to say about that.
Thank you very much. Thank you, Chair.
Okay, thank you. Members, any other questions? Seeing none, we will move on to House Bill 929 relating to qualified domestic relation orders. Kanoy Margot, ERS.
Good afternoon, Chair, Vice Chair, members of the committee. I'm Kanoy Margot, Deputy Executive Director for the ERS. The ERS Board of Trustees strongly supports this bill and encourages its passage. I'd just like to highlight a few things in our written testimony. This proposal is primarily a housekeeping measure related to the Hawaii Domestic Relations Order, also known as hydros. You may recall that the ERS began processing hydros on July 1st, 2020, which allows the ERS to make direct payments to alternate payees, such as former spouses of ERS members. This proposal is an effort to facilitate its current implementation by clarifying the benefits payable to the parties involved and the processing of these orders. Thank you for your consideration. I'd be happy to answer any questions.
Okay, thank you very much. That's all the testimony we have on this matter. Any questions? Okay, seeing none, we will move on to House Bill 1075 relating to emoluments. We have Bonita Chang, Hawaii Ethics Commission.
Good afternoon, Chair, Vice Chair, members of the committee. Bonita Chang, Staff Attorney with the Hawaii State Ethics Commission. We rest on our written comments, and I'm available to answer any questions that you may have. Thank you.
Okay, thank you very much. Okay, that's all the testifiers we have on this bill. Any questions, members? Representative Ward.
The Ethics Commission,
Yes, Chair. Yes.
what is your sense of why this bill is now rather than before? What's your chronological assessment?
I'm not really sure. We just were asked to comment on the bill. I think in terms of the history, my understanding is last year the legislator enacted Act 75, which addressed emoluments and outside employment for the governor. And I think this particular bill is seeking to amend that. I think it's under 84-14.5 to include the lieutenant governor as part of that provision.
It has nothing to do with the 2022 election.
I'm not really, I can't really speak to what are the intent behind it.
That was a rhetorical question. Some people are thinking in the back of their mind. Thank you.
Okay, thank you. Members, any other questions? If not, thank you very much. Next, we go to House Bill 1075. Oh, I'm sorry, we just did that. House Bill 662 relating to firearm ownership. First, we have Lee S. Hayakawa, Office of the Public Defender.
Hi, good afternoon, Chair, Vice Chair, members of the committee. I am the Assistant Public Defender, Lee Hayakawa. We submitted commentary on this on HB 662. We are available for any questions. Thank you.
Okay, thank you very much. Brian Lay, Hawaii County GMAC. Okay, not present. Mark Tom, Department of the Prosecuting Attorney, Honolulu.
Chair, Vice Chair, members of the committee, Deputy Prosecuting Attorney Mark Tom for the department. Department stands in opposition and will rest on its written testimony.
Okay, thank you very much. Brandon Yamamoto, Honolulu Police Department.
Good afternoon, Chair, Vice Chair, committee members. Captain Brandon Yamamoto, representing Honolulu Police Department. We will be standing on our written testimony submitted. Thank you.
Thank you very much. Todd Yukutake, Hawaii Firearms Coalition.
Aloha Judiciary Committee, Todd Yukutake with the Hawaii Firearms Coalition. We strongly support HB 662. This bill provides an avenue for good people to have their Second Amendment rights restored. A lot of people make mistakes in the past, like one of my friends, he used to go hunting as a kid, but kind of messed up when he was young. And 20 years later, he has a family and he wishes he could teach his kids how to go hunting. So this bill would help him a lot. Hunting is a good source of recreation, food source, also brings people closer to nature. So this is kind of like a healing bill for a lot of people. This is also Hawaii also has a very low rate of governor pardons too, which could restore Second Amendment rights. But Hawaii is one of the lowest in the nation on average for governor's pardon. So this gives people a second avenue through the courts to get their Second Amendment rights back. But please support HB 662. Thank you.
Okay, thank you very much. Okay, members, beyond that, we have numerous individuals in support and some in opposition. However, none of them are scheduled to be here. Members, any questions for testifiers? Okay, seeing none, we will move on to House Bill 199 relating to electronic proclamations. Office of Elections, Scott Nago.
Thank you. The office will stand on its written testimony in support.
Okay, thank you, Ms. Nago. Sandy Ma, Common Cause.
Good afternoon, Chair, Vice Chair, and members of the committee. Sandy Ma for Common Cause Hawaii. We support this measure. We just have some suggested amendments. We hope that the clerk's proclamation will include a listing of the locations and the dates and times, the hours of operations of the voter service centers and the places of deposit. This will help the public know where the voter service centers and the drop boxes are located and when they may be used. Thank you.
Thank you very much. That's all the testifiers we have on this measure. Members, any questions? Representative Ward.
Mr. Nago, please. Mr. Nago, this kind of gives your clerk the, I guess, the kuleana to do the proclamation. Is that something that you find it would be better in the clerk's hand rather than yours as you being the chief elections officer?
So the way the law is set up is the clerks are responsible, each county clerk is responsible for places of deposits at voter service centers. So this bill amends that law, our requirement of issuing a proclamation in case of a change to one of those two things to the clerk rather than the chief election officer. So we feel it saves time, that would be needed to let voters know.
So it was improper to put the chief election officer yourself in that position, but it only says clerk. It doesn't say clerks.
So it's the clerk of each county.
Clerk of each county. Okay, thank you. Thank you, Chair.
Okay. Members, any other questions? Okay, seeing none, we will move on to House Bill 248 relating to personal relationships. Department of Health.
Good afternoon, Chair, members of the committee. Lauren Kim, Policy Director and Acting State Registrar, testifying in strong support of this measure. And I'm here to answer any questions the committee may have. Thank you.
Okay, thank you very much. We have several individuals also in support of the measure, but no other testifiers present. Members, any questions on this measure?
Sure, I have a
Representative Ward.
I have a silly question. If the Boy Scouts qualify as a civil celebrant and someone wants to do marriages, do they qualify under this bill? Anyone on this call could answer that?
Rep Ward, this is Lauren Kim, Department of Health. We do have rules and policies and procedures in place as to marriage officiants that would apply. You would have to be over 18, so on and so forth. But if you're talking about an entity or an affiliation of an individual, this is really intended for individuals rather than, say, an organization. They may apply under the umbrella of a religious organization, but the intent, and we would support clarifying amendments to assure that the rights of individuals and or entities are respected. And again, for example, a religious organization may apply as an entity, and a civil organization or non-religiously organization may also be encouraged to do so.
Because on line 12, it says, as used in the section, civil celebrant means a member of a secular or non-religious organization who is authorized by the organization to solemnize.
Chair, I don't know if you can hear me, but I think our internet connection is unreliable.
I believe their Wi-Fi dropped out because none of their profiles are visible.
Okie doke.
Okay, we'll take another short recess as everybody else comes online.
I don't know at which point we cut off, so with the chair's indulgence, I'll try to answer Rep. Ward's question about whether the Boy Scouts of America would qualify as a non-religious entity that would have the authority to quote unquote ordain or authorize someone to officiate a marriage. As written, I would say yes. Our intention was to make sure that non-religious affiliated individuals and organizations had the same opportunities as religiously affiliated organizations to solemnize marriages. If there's an opportunity to provide clarifying amendments or even amending our rules to make it clearer, we are open to those amendments.
Thank you for that clarification, because I was really thinking about the Chamber of Commerce and the economic interest that this might attract. Thank you. Thank you, Chair.
Okay, thank you, members. Any other questions? Seeing none, move on to House Bill 31 related to firearms. Todd Yukutake, Hawaii Firearms Coalition.
Hi, Todd with the Hawaii Firearms Coalition. We oppose HB 31. Minors under age 18 can be responsible with firearms, and this would deny them of the ability to use it. One of the primary reasons is for self-defense. A lot of the time, minors are left at home. Mom and dad are working, and they have to be able to defend themselves. If a gun is stored away, they can't be able to access it. Same is true if they're watching grandma and grandpa. There's been some home invasions recently. I think the latest one was Makiki, I believe, where some criminals broke into someone's home and tied up an old man, the resident in the house. Second reason is for hunting and target shooting. In the past, like for example, my cousin, when he was in high school, he used to go hunting after school with his high school friends, and he would need access to the firearms in order to do that. And they can still do that today, especially on the outer islands. That still happens. If this law were to take effect, they might not be able to do something like that anymore. But yeah, children can be responsible, especially 16, 17-year-olds. I see kids like that at the shooting range. They do the run and gun, and some of them are better shooters than I am. But being able to handle firearms takes a lot of responsibility and accountability, and I think that's a good thing for youth. And I can see your concern about the safety of the minors. I am the NRA State Training Counselor for Hawaii, so I train the instructors here. Whether this bill passes or not, I'll work with the firearm instructors to emphasize safe storage of firearms and youth issues in that regards. Also work with the stores, may do some videos, public service videos. And there are companies that, one of them is National Shooting Sports Foundation. They'll send free gun locks upon request to people. But for those reasons, I oppose HB 31. Thank you for your time.
And thank you very much. Dear members, we have numerous other testimonies in opposition and comments. Are there any questions for the testifiers? Okay, seeing none, then we move to House Bill 341 relating to administrative procedure. Wayne Tanaka, Office of Home Affairs.
Hi, good afternoon, Chair, Vice Chair, members of the committee. Wayne Tanaka for the Office of Foreign Affairs. The Office of Foreign Affairs opposes this measure. You have a written testimony that kind of explains their position. I just add that declaratory rulings and petitions for declaratory rulings are an issue of access to justice. For a lot of Native Hawaiians, this is how they can ensure that the law is consistently and fairly applied to the extent that it may protect their their constitutional rights. And it's also a process that's relied upon by basically any member of the public. If any agency has rules or laws that have to be applied to particular situations, and it's an easy way for them to have those laws applied without having to go to the courts and so forth. And I'll just add to that. I'm not sure. It's not like you still have to overcome some requirements such as standing. So it's not like just anyone can petition an agency anytime and then use up administrative resources. So I'm not sure if there's actually a problem that in terms of the declaratory ruling and petition process being misused to the extent that it would merit kind of really diminishing this important access to justice mechanism. Happy to answer any questions. Otherwise, we respectfully ask that the committee consider holding this measure. Thank you.
Thank you very much. Robin Wurtzel?
Yes,
Civil Rights Commission.
Chair, Vice Chair, and members of the committee. I'm Robin Wurtzel, speaking for the Hawaii Civil Rights Committee. We submitted testimony in opposition to this bill, but I do want to reiterate that the bill eliminates the due process right of appeal and judicial review. It defeats a basic tenet of administrative law. It will really change the procedure for those seeking declaratory relief. It would mean that it will not just defeat one of the basic tenets of administrative law, it will also increase the burden on the judiciary, because it'll mean that if you give up your right to appeal in an administrative agency, you'll skip it and go straight to court. At which point you'll be able to appeal to the Intermediate Court of Appeals and the Supreme Court. So it actually will increase the burden on the judiciary, which is the point of administrative agencies, to decrease that burden. We respectfully ask that the committee hold the bill. I'm available for any questions.
Okay, thank you very much. Marty Townsend, Sierra Club.
Aloha, Chair, Nakashima, and members of the committee. I'm Mari Townsend with the Sierra Club, and we will join the voices in opposition to this bill. In addition to the testimony from the Civil Rights Committee and the Office of Foreign Affairs, which we share, due process constitutional issues, violates the doctrine of separation of powers between the three branches of government. It also just creates an immense amount of confusion. I mean, just think about it. You'll have agencies racing against each other to make rulings where they feel like they have shared authority, or they'll be beefing with each other about who has sole jurisdiction. You really will sort of upend the way in which we have been working together to try to figure out how to get agency decisions made and to make sure that people's rights are well protected. We really strongly urge the committee to hold this bill. There's way too much confusion, and the constitutional principles that you're challenging, they are fundamental, and this bill does not respect them. Thank you very much.
Thank you. Okay, members, that's all the testifiers that will be appearing before us today. Any questions? Representative Matayoshi.
This is a question for Robin. I'm wondering if you know how often how often an agency appeal actually gets over that? How often the initial decision on an agency appeal actually gets overturned prior to court?
So I'm having a little bit of trouble hearing you. I'm sorry, and I'm looking at the captions, but they're not particularly good.
Actually, sometimes the
You're
captions
asking
are-
how often
How often for an agency appeal, how often is the initial decision overturned on an agency appeal?
Well, this particular bill only deals with declaratory relief, not agency decisions. So we actually do contested case hearings, which actually do get overturned in court. Like we don't have that many at HCRC, but I'd say 1 in 3 is probably, well, when they're appealed, maybe even half.
Oh, wow. Okay. I didn't realize they were that high.
It's maybe not. I'm trying to think, we've only had a few that get appealed. Sometimes they settle when they're on appeal, but I guess it's more like, yeah, it's probably more like a quarter. But the deck relief is particularly important, I think, because it deals with a question of law, not a particular case.
Okay. And can you briefly just comment on the other testifier's statement that agencies may be rushing to assert jurisdictional claims over a certain topic? Do you see that as being a problem or not?
Yeah, I think it could be. That was the Sierra Club, and we were trying to figure out what other agencies would. I don't know how that would affect us in particular. I think it might affect things like some of the environmental issues in terms of the different agencies that hold sway. For us, I can't actually speak to that. I'm not an expert.
Okay, thank you.
It's certainly not a good precedent, though, to pit us against each other.
I mean, arguably, that this, from my understanding of this bill, and I could be wrong, this is trying to prevent you folks from being pitted against each other through conflicting declaratory actions by not allowing one agency's decision to be overturned by another agency with joint jurisdiction. So,
well, and I don't know how often there is joint jurisdiction. Like we sometimes come up with we sometimes look at unemployment decisions in terms of discrimination, but it doesn't affect, they're still different. I mean, one would be a discrimination decision. One is like a work comp decision or an unemployment decision. And for us, they have not overlapped. If we were in fact bound to another agency's decision, we would be very unhappy. Like if we were bound by an unemployment decision regarding the status of an employee, it would not be good for the employee.
Okay, thank you.
Okay, members, any other questions? If not, we'll move to House Bill 359 relating to statute of limitations. Oh. 357. Oh, I'm sorry. David Day, Deputy Attorney General.
Good afternoon, David Day, Deputy Attorney General. We submitted testimony in support with comments. I'd just like to reiterate or state a few things. Inverse condemnation claims, and in particular, regulatory taking claims, are among the most expensive claims that can be asserted against the state, and certainly the ones with perhaps the most exposure for any single actions of any branch of government. And unlike every single other claim that we're aware of that can be asserted against the state, whether it be contract, state, statute, rule, tort, breach of fiduciary duty, which are all 2-year statutes of limitations. In the DWI and Alea case that just came out in December, the court ruled 6 years for regulatory takings claims. And we think that greatly increases the exposure that can be placed, or I guess the fiscal exposure that the state has with respect to these claims. It also allows potential claimants to not alert the state or the state agencies or whoever it may be that there is an issue, and during that time, financial liability can continue to grow, where under the doctrines of just compensation, essentially that liability could be very limited, or actions could be taken to limit liability promptly, in fact. We suggested one change, one amendment, which would be to change the language referencing regulatory takings to inverse condemnation. The DWI and Alea case made clear, I shouldn't say clear, it was at least strongly suggested that the holding holding of a 2-year statute of limitations only concerned so-called regulatory takings, which is when either an administrative agency or the legislature makes some sort of regulation of land or property, which greatly diminishes the value. And that's the only type of taking claim that the ruling related to, rather than so-called physical takings or physical invasions of land, which can also be very expensive and also share a lot of similarities with regulatory takings. So we suggest that the language be amended to provide that the statute of limitations for all inverse condemnation claims be 2 years. And other than that, I'll stand on my testimony. Thank you.
Thank you very much. That's all the testimony we have on this matter. Members, any questions? Seeing none, we'll move to House Bill 818, relating to criminal trespass on state lands. Tasha Forrester, Hawaii Public Defender.
Aloha Chair Nakashima and members of the committee. The Office of the Public Defender opposes this measure. We don't think it's necessary. The Hawaii Rules of Evidence, as codified in Chapter 626, already govern evidence and authentication, and things like photographs, video recordings, and surveillance video are regularly entered into evidence in cases in the court system. So we just don't see the need for this. Thank you very much for allowing me to testify.
Thank you. Mark Tom, Department of the Prosecuting Attorney.
Good afternoon, Chair, Vice Chair, members of the committee, Deputy Prosecuting Attorney Mark Tom for the Department of the Prosecuting Attorney's Office. Chair, we will just offer comments and stand on our written testimony.
Thank you very much. That's all the testifiers we have on this measure. Members, any questions? Yes. Seeing none, we'll move on to House Bill 542. Relating to the Uniform Controlled Substances. Jared Didula, PSD.
Yeah, good afternoon, Jared Redula, the State Narcotics Chief for PSD. We'll stand on our written testimony in support.
Okay, thank you very much. Nahilani Kale Kelsey Webster, Greenwich Bioscience.
Good afternoon, Chair and members of the committee. Nahalani Webster testifying on behalf of Greenwich Biosciences in support of HB 542. Just want to highlight that this measure applies to an important medication known as Epidiolex. Epidiolex is currently the only FDA-approved plant-derived cannabinoid product and will be there for the treatment of 2 rare forms of childhood onset epilepsy. In 2020, Epidiolex has also been approved for the treatment of tuberous sclerosis. Descheduling from the Uniform Controlled Substances Act will conform with recent updates in federal law. It will also improve access for patients in that prescriptions may now be transferred electronically, and doctors may prescribe for up to 1 year versus the 6 months. Thank you for the opportunity to testify and available if you have questions.
Thank you. Next, Clifton Otto, Akamai Cannabis Clinic.
Yes, can you hear me?
Yes.
Good afternoon, Chair, Vice Chair, members of the committee. Thank you for the opportunity to testify on this measure. My name is Dr. Cliff Otto. I'm a medical doctor and practicing cannabinoid medicine specialist in Hawaii. I support this measure and just wanted to offer some brief comments to expand upon my written testimony. This bill is very important because it shows how necessary it is to harmonize the state and federal regulation of controlled substances. In this instance, a Schedule 5 controlled substance was removed from the Federal Controlled Substances Act, and by removing that from the State Uniform Controlled Substances Act, that allows this the regulation of the and sale of this substance to be coordinated between state and federal governments. On the other hand, we have Hawaii's medical cannabis program, which is a prime example of what happens when you do not harmonize the state and federal regulation of controlled substances, and in this case, a Schedule 1 controlled substance. As a result, we have a conflict with the federal regulation of marijuana that is causing discrimination against our patients and against businesses that want to engage in this state-regulated program. So what I am proposing is an amendment to the bill that would use existing federal administrative processes to have the Department of Public Safety file an application for immediate relief with the DEA and also a petition for permanent relief with the DEA based upon the state's authority under the US Constitution to decide how controlled substances are used within the state, and the fact that the state has never gone back to the DEA to try and harmonize the state and federal regulation of the state authorized use of cannabis under state law for medical purposes. So thank you for considering this amendment, and I'm available for any questions.
Thank you. Yeah, that's all the testimony we have on this measure. Members, any questions?
Chair.
Representative Ward.
Dr. Otto, question. Are you suggesting the bill doesn't go far enough and you want to go beyond, or is it going beyond which would make the bill better? Which is more important, the bill or your amendment to it?
I think the two together are equally important because the bill as it currently stands does something that is very necessary and something that has to occur every year, where changes in federal scheduling are similarly conducted at the state level so that this substance can be regulated properly. But that doesn't mean that this harmonization only occurs from the federal to the state direction. It can also occur to the state up to the federal direction because of the state's constitutional authority in this area. So what I'm suggesting actually is that my amendment and the bill as it stands be considered together, because they both deal with this same concept of preventing conflicts in the state and federal regulation of controlled substances.
Okay, I see your point. It's only that the time has not arrived for that particular amendment, and then you want to put it into this one. Thank you very much. Thank you, Chair.
Thank you, members. Any other questions? Okay, seeing none. Thank you very much, Doctor.
Thank you.
Next, House Bill 1138. Relating to abuse. Darcia Forrester, Office of Public Defender.
Aloha, Chair Nakashima and members of the committee. The Office of the Public Defender strongly opposes House Bill 1138. We'll stand on our written testimony, and I'm available if anyone has questions. Thank you so much.
Okay, thank you. We do have a number of other testimonies and support. However, none of them will be present. Members, any questions? Okay, if not, we will move on. House Bill.
Chair, I have a question.
Oh, Representative Presley.
For the Office of Public Defender.
Hello.
I just was hoping you could articulate a little bit, because it's already a crime, right? This just elevates it to a felony. And is there problems prosecuting the misdemeanor?
No, I wouldn't say there's problems prosecuting the misdemeanor. It's just moving a misdemeanor level of act into the realm of the felony division just based on the fact that there are children present. This bill specifically raises that age from 14 to 18. So that's sort of the purpose of the bill, but cases are prosecuted in misdemeanor court all the time.
So you wouldn't be supporting domestic violence
No.
just by opposing this, obviously, right?
No.
Just we don't
To be
need
clear,
necessarily more felonies.
we do not support domestic violence, but we are concerned that there seems to be a trend to move misdemeanor level acts into the felony courts. And every year we're just seeing more and more situations being added to felonies. And having a felony conviction or being charged with a felony has a lot of collateral consequences that go beyond just the crime itself. Our office's position is that if it's your first offense, you should have it. For a misdemeanor level act, you should have the ability to show in misdemeanor court that you can do the classes, educate yourself, comply with what you need to comply with. If it's a problem, you're going to end up in felony court anyways. But
Thank you.
so, thank you.
No, that's sufficient for my interest. Thank you so much. Thank you, Chair.
Okay, thank you. Next is House Bill 1090 related to child passenger restraints. First up is Ed Sniffen, Department of Transportation.
Hi, good afternoon, Chair, Vice Chair, and members of the committee. This is Lee Nagano from the Department of Transportation. We'd like to stand on our written testimony in support of this bill. Thank you for the opportunity to testify.
Okay, thank you very much. Calvin Tong, Honolulu, please.
Good afternoon, Chair, Vice Chair, members of the committee. Major Calvin Tong with the Honolulu Police Department. We stand by our testimony in support of this bill.
Okay, thank you very much. And then last, Lisa Dao, Kapiolani Medical Center.
Good afternoon, representatives. Lisa Dow with Kapiolani Medical Center and Safe Kids Hawaii. And we stand by our written testimony in support of this bill.
Okay. Okay, members, that's all of the testifiers we have on this measure. Are there any questions? Seeing none, we will move on to House Bill 1366 related to firearms. Max Otani, PSD. I'm sorry. Brandon Yamamoto, Honolulu, please.
Good afternoon, Chair, Vice Chair, and members of the committee. Captain Brandon Yamamoto with the Honolulu Police Department. We will stand by our written testimony in support of this bill with comments. Thank you.
Okay, thank you very much. John Abbott, Hawaii Firearms Coalition.
Good afternoon, Chair, Vice Chair, and members of the committee. My name is John Abbott. I am one of the directors of the Hawaii Firearms Coalition, and we're opposed to this bill based upon the fact that people have a right to manufacture their own firearms and have since the beginning of the country. This bill not only, well, the previous ghost gun bill removed the ability for most people to manufacture their own firearms, but this bill actually retroactively takes their own legal property that they purchased and manufactured under the law. And that's just not right. We strongly oppose this bill.
Okay, thank you very much. Daniel Reed, NRA.
Yes, Mr. Chair and members of the committee, for the record, Dan Reed, Western Regional Director with the National Rifle Association. We're here in strong opposition to House Bill 1366. As mentioned, this retroactively applies Act 74 from the 2020 session, which was an effort to ban home-built firearms or so-called ghost guns. The language of Act 74 was very vague, overbroad as to what could actually constitute parts that could subject someone to felony penalties, making it far too easy for a well-intentioned person to run afoul to the law. And so with this legislation, it only compounds the problem by looking backwards, potentially subjecting someone to property they currently possess to harsh penalties for something that they were engaging in lawfully at the time. With that, we're in opposition. Thank you.
Thank you very much.
For the certificate.
Michael Tano, aye. Not present. Ryan Tana Jero.
Hello, sir. I'm here.
Legit.
No, we didn't have it. Check the format.
Representatives, can you hear me? All right. Representatives of the Judiciary and Hawaiian Affairs, this is Ryan Tenhero. I stand by my written testimony in opposition to this measure as it is written. It serves as an ex post facto measure, and here's the concern. In accordance with the Legal Info Institute, basically defined, every law that makes criminal an act that was innocent when done, or that inflicts a greater punishment than the law annexed to the crime when committed, is an ex post facto law. This measure, if enacted, would essentially serve as a de facto ex post facto law. It criminalizes persons who own a non-serialized firearms receiver who lawfully acquired it prior to September 15, 2020, without any real action on their part. It's just they have it, and then a signature is enacted on this measure, and that person becomes a Class C felon. There's no added safety or public benefit in general, other than an increase of Class C felonies. Moreover, there's no recourse for the people of Hawaii if they find out that they just become overnight a Class C felon. It is abhorrent to know that someone could just know that their activity, although legislated against them, makes them a felon, and there's no action, again, taken on their part. I advise this committee to keep Section 6, not make the law retroactive, so that persons don't become felons by no action of their own, and focus your efforts on better, more constructive bills such as HB 1324, the Commercial Rent Relief Program, that could assist businesses and also restore our economy. This will be more beneficial to families, their children, and also the rest of Hawaii, your constituency in the state of Hawaii. I'm available for any questions if you have any. I thank you for your time.
Thank you very much. Next, Todd Yukute.
Okay. Again, good afternoon, committee members. Todd Yukutake. I agree with everything that was stated in the opposition before and in my testimony. Do want to add that in my testimony, toward the bottom of the page, I listed the U.S. Constitution, Article 1, Section 10, Clause 1, about retroactive laws. I have it bolded and underlined. No state shall pass any ex post facto law. Cannot pass any criminal law that's retroactive. So that instantly makes this bill unconstitutional, even if you don't look at the Second Amendment violations to it. The other thing is, if you do pass this law, like was said before, a lot of people will be instant felons. There's really no way to avoid that. And even if people aren't arrested or charged, for those that have to apply for security clearances, like for the military or federal government, One of the questions is, have you committed any crimes or felonies? Even if you weren't arrested or charged, they will have to put yes for that because they violated this retroactive law, and could ruin their employment opportunities in the future. But that's all I have. Thank you very, very much.
Thank you. Justin Lee Solomon. Not present. The members, there are numerous testimonies in opposition. Members, that's all the testifiers we have. Any questions? Okay, seeing none. House Bill 1117 related to vacancies. Scott Nago, Office of Elections.
Thank you. The Office of Elections stands on its written testimony providing comments.
Okay, thank you. And that is all the testifiers we have on this bill. Members, any questions? Representative Ward.
Mr. Nago, how much does a special election cost? Roughly ballparkish.
So we have it in our testimony on page 2. It just depends on what contest it is. It can range anywhere from a U.S. Senate seat, which would be 2.3 million, to a House seat, which would be 223 million.
Thank you for that. I didn't get that testimony, so that's very helpful. Thank you. Thank you, Chair.
Okay. Members, any other questions? Okay, if not, thank you, Mr. Nago. House Bill 1009 related to certain penalties for violation of Subtitle 4 of the Hawaii Revised Statutes. David Smith, DLNR.
Good afternoon, Chair, Vice Chair, and members of the committee. Irene Sprecher here for David Smith with the department as well. He's in another meeting, but I can testify on this matter. The department is in strong support of this administrative measure because it does 4 important things. The first one is update our administrative fines for forest product theft. Last time they were updated was in 2016, and since then, the value of our variety of forest products has substantially increased, so it's no longer a successful deterrent. It also extends criminal penalties to any violation associated with the forest reserves. Currently, the only criminal penalties we have is related to timber theft, so that would clean things up and give us some better enforcement ability for other violations. At the same time, it also looks to exempt minor offenses like related to traffic offenses. And then it cleans up some duplicative language regarding general and civil penalties. You have our comments within our testimony, and I'm here and available for any questions you might have. Thank you.
Carrie Sprecher, you are also listed as a testifier. Do you have any further comments?
No, that's all I have. Thank you.
Okay. Okay, members, that's the testimony we have on House Bill 1009. Any questions?
Chair, very brief
Representative
question
Ward.
to DLNR. What is the experience rating or the incidence? Are people stealing coal wood, selling it, burning it? What's going on?
Yes, we do have incidents every year, both related to attempted theft or theft of koa and more recently Iliaki or Hawaiian sandalwood. So it is something that does occur within our public lands.
How often is that taking place?
I would say we have 1 to 2 incidents at least a year.
Okay, thank you. Thank you, Chair.
Okay, thank you very much. Members, any other questions? Okay, seeing none, we'll move to House Bill 1096 related to parentage. Brandon Brandon Flores, Attorney General. Not present. Department of Health.
Good afternoon, Chair Nakamura, members of the committee, Lauren Kim, Policy Director and Acting State Registrar, submitting comments. I'd like to highlight a couple of them that echo what I understand to be the main points of the testimony, written testimony from the Attorney General, that we don't take a position on the public policy merits of it. We have a ministerial function to document and record this vital record, but it does create some unintended consequences, and we are willing to work with stakeholders to redraft the bill. I'm not sure there's enough time before crossover or working in the off session to produce a bill that diminishes those and eliminates those unintended consequences. There are federal reporting provisions we have that may be disrupted. There is the potential that non-biological or gestational parents may, quote unquote, declare themselves a parent. And that's a very small, very small risk, but we certainly want to make sure whatever statute gets enacted or passed through committee is as strong as possible in its protections. So we stop short of asking that this bill be deferred, but we do need to work with stakeholders. Perhaps if you can hold off decision-making until we have a chance to gather with stakeholders, including the Department of Human Services and the AG, to figure out what next steps can be accomplished in the time that we have. We respectfully suggest that course of action. There are too many unanswered questions that this bill creates, but we are willing to work with folks to come up with something that does meet the public policy potential that this HB 1096 proposes. Thank you, and I'm available for questions.
Okay, thank you very much. Sarah Hammond, Affirm Hawaii.
Sarah Hamid. Is that what you're trying to say? Can you hear me?
Yes.
Sarah Hamid. Yes, I think you're referencing me. I just couldn't hear you.
Okay.
Is it? I'm trying to ask. Is the name Sarah Hamid or is it someone else? I couldn't hear you clearly.
It is you. Yes.
Okay. Thank you. Aloha Chair, Vice Chair, and committee members. Mahalo for the opportunity to testify today on this measure. My name is Sarah Hamid with the firm Hawaii, and we testify today in strong support of House Bill 1096. We stand on our written testimony, which you have before you, but would like to highlight the urgency of this issue. Hawaii is often regarded as a state that is LGBTQ friendly due to our consistent history in standing in strong support of LGBTQ rights. However, this does not erase the imminent reality and discrimination against LGBTQ people in Hawaii that is not only alive and well, but rampant. LGBTQ parents are whole, valid, and real, but in Hawaii, they are treated as wrong. Paternity law, otherwise known as the Uniform of Parentage Act in Hawaii, only allows male partners for people of unmarried couples giving birth in hospitals to voluntarily establish their parental rights at the time of birth. LGBTQ plus parents are then forced to obtain post-birth adoption decrees that cost thousands of dollars, otherwise known as the queer parent penalty, placing an extreme financial and emotional burden on queer families. Restricting establishing parenthood to those who identify as male is an unconstitutional restriction based solely on cisgender and heteronormative concepts of parenthood and is not based on ensuring a biological relationship or substantive relationship between parent and child. As we sit here today, hundreds of babies have been born to LGBTQ families throughout the duration of the COVID-19 pandemic, and many have faced extreme financial hardship in obtaining these post-birth adoption decrees. This has prevented LGBTQ families from enrolling their children in healthcare benefits, preschool programs, government benefits, etc. The pandemic has only highlighted the unjust expectation that LGBTQ parents are not regarded as valid in the eyes of the law. House Bill 1096 would correct this and would considerably improve the conditions of LGBTQ people in Hawaii. by opening and allowing the voluntary establishment of parenthood to partners of all gender of a birthing person, regardless of their gender identity or biological contribution to the child. COVID-19 has not only exacerbated the stigma faced in hospitals and healthcare spaces faced by queer families, but the financial stress too. Granting equal rights for LGBTQ parents is urgent, and House Bill 1096 is the fix we need for a future without LGBTQ oppression in Hawaii. We are able and willing to take any questions. Mahalo for your time and dedication.
Thank you very much. Jasmine Pontelis Davy.
Oh, here, one moment, please. I thank you, Chair, and honorable members of the community, of the committee for the opportunity to testify in strong support of HB 1096, amending the Uniform Parentage Act. My name is Jasmine Pontias Dave. I am an attorney, and I would like to speak briefly to how the current statute allowing only the voluntary establishment of paternity and not the gender-neutral voluntary establishment of parentage is an unconstitutional restriction on the rights of non-male people in Hawaii on the basis of their gender identity. When a statute negatively impacts certain protected classes, the constitutionality of that statute can and should be challenged and examined. In 1976, the US Supreme Court case Craig v. Boren created the intermediate scrutiny test, which is applied when a statute discriminates on the basis of gender identity, which is now recognized as a protected class. The intermediate scrutiny test states that the discriminatory statute must, 1, further an important government interest, and 2, it must do so by means that are substantially related to that interest. Since there is no requirement that a male person volunteering to establish their parentage undergo a genetic test to establish a biological relationship between themselves and the child being born, it cannot be said that the important governmental interest behind only allowing male-identified people to volunteer parentage is the assurance that the person has made a biological contribution to the child. A non-gestational parent's reproductive functions do not matter according to the present law, and the statute therefore only allows certain people to volunteer their parentage on the basis of their gender identity alone. Genetic relationships between parent and child may be challenged in court, and it would be inappropriate and overly invasive for the state government to require a DNA test upon the birth of every child. I respectfully ask the committee to ask itself what message the state of Hawaii wants to send to the rest of the world regarding how gender identity is respected here, because there simply is no government interest, important or otherwise, being served by only allowing men to volunteer to legally identify as the parent of a child when biology is not the determining factor. Thank you.
Okay, thank you very much. Monique Simone.
The Uniform Parentage Act, as it currently stands, discriminates against queer families and our ability to establish parental rights under law without unjust burden. I strongly urge you to pass this measure and end the unconstitutional restriction on the equal rights of LGBTQ+ people and our path to parenthood. As a lesbian parent who recently welcomed my son, Teddy, last June, I speak firsthand to the hardship of pursuing a family as an LGBTQ+ couple. From locating a donor that ethnically represented our family and provided uncontested legal protection against paternity disputes, to finding medical providers who did not actively discriminate against us. On top of the costs of actual fertility procedures, there were countless hurdles we faced along the path to building our family, both emotionally and financially. As the non-gestational parent to Teddy, there were many hours spent consulting a lawyer regarding the security of my parental rights in various scenarios as the non-biological parent. I am no less his mother than the woman that birthed him. Yet every step of the way, I am questioned because I'm not a cis hetero man. LGBTQ+ people already face tremendous obstacles on this parenthood journey, forcing us to additionally spend upwards of $20,000 to adopt our own children is discriminatory and cruel. Biology, gender identity, and marriage should not be determinants of who is granted the opportunity of parenthood under law, nor are they markers of what makes a family legitimate. Queer people know better than anyone that family goes beyond biology. As you know, legal parenthood has a tremendous impact on a parent's ability to care for their child. It allows them to enroll in school, make medical decisions, and legally travel with the child. If male partners have the ability to volunteer parenthood, queer partners should be able to do the same. Mahalo for your opportunity to testify on HB 1096 and for your consideration of this critical bill.
Thank you very much. Next, Ashley Galagak.
Present. Aloha, Chair Nakashima, Vice Chair Matayoshi, and members of the House Committee. My name is Ashley Galagak, and thank you for the opportunity to testify. I want to highlight specific points in my written testimony for HB 1096. As a proud member of the LGBTQIA community, this bill will directly impact the lives of loving couples like my partner and me, both of us born and raised here in Hawaii. We dream to raise our future children here. It has been disheartening to listen to countless stories of friends, of colleagues, all in our community jump through these legal and financial hoops. And this is on top of the struggle to conceive children and struggle to gain the parental rights with the adoption process. Listening to these stories is in full I am fully aware with the many barriers. And when this opportunity to change that, I'm here to testify to put a face to many stories that I've also listened to. The bill would update the law to give legal rights, recognition, and protection for LGBTQ families that they deserve, and it acknowledges that it is more than biology to be a parent. Parents of any gender identity should be able to establish their valid and legal rights to their children. And being on the birth certificate is the first. Without this correction in this bill, LGBTQ parents will continue to face barriers in parenting their children and are treated as second-class citizens under the law. I ask that with your leadership, you are listening to our stories and be dedicated to the commitment to provide the equal rights for our community. Thank you.
Thank you very much. Members, that's the last of the testimonies that will be testifiers that will be present today. Are there any questions? Okay, seeing none, we will recess for decision making. Recess. Okay, good afternoon, members. If we can move into decision making on HB 884 relating to Office of Informational Practices. The Office of Informational Practices has submitted some amendments they'd like to see regarding written guidance in the bill. So I'd like to incorporate their testimony into the bill. Any questions or comments? Okay, seeing none. House Draft 1, Vice Chair.
The Chair's recommendation is to pass HB 884 with amendments. Chair and Vice Chair vote aye. Representative Ichiyama? Aye. Representative Kobayashi?
Aye.
Representative Lopresti?
Aye.
Representative Lowen?
Aye.
Representative McKelvey?
Aye.
Representative Nakamura?
Aye.
Representative Takumi? Can I give you excuse if you want? You know. Representative Todd? Oh, there's the excuse. Representative Tokioka?
Aye.
Representative Ward?
Aye.
And Chair, your recommendation is adopted.
Okay, thank you very much. Members, House Bill 659 related to property forfeiture. We'll defer this measure. House Bill 929 relating to qualified domestic orders. Chair's recommendation is that Chair knows that there are a few ramps errors throughout the bill, and other technical amendments are needed for clarity, consistency, and style. So House Draft 1, members, any questions or comments? Seeing none, Vice Chair, House Draft 1.
Chair's recommendation is to pass HB 929 with amendments, noting the previously excused members, any members voting with reservations, any members voting no. Chair, your recommendation is adopted.
House Bill 1075 relating to emoluments. Chair's recommendation is to pass this out as is. Members, any questions or comments? Representative Ward.
Chair, the timing of this makes this bill very suspect. It's too close to an election, which we know who the contenders are, and it seems to single out the lieutenant governor for some reason that I don't understand, other than it being political. For those reasons, I'm going to be voting no. Thank you.
Thank you, members. Any other questions or comments?
Question, Chair. So we're assuming the governor would never, this only is for the lieutenant governor. Because we make the assumption there's no way the governor would have outside imposed.
The governor was already taken care of last year.
Also, the governor cannot have a part-time job.
No.
I'm not running for governor.
Running for lieutenant governor?
Thank you.
Okay. Members, any other questions? Seeing none, Vice Chair as is.
The Chair's recommendation is to pass HB 1075 as is, noting the no vote from Representative Ward and the previously excused members. Any members voting with reservations?
Reservations.
Representative Tokioka with reservations. Any other members? Any other members voting no? The Chair, your recommendation is adopted.
Thank you very much. House Bill 662 relating to firearm ownership. Chair's recommendation is to move this out as is. Members, any questions or comments? Seeing none, Vice Chair as is.
The Chair's recommendation is to pass HB 662 as is. With Vice Chair voting with reservations. Any other members voting with reservations? Any members voting no? All right, noting the previously excused members, Chair, your recommendation is adopted.
Okay, thank you very much. House Bill 199 related to reservations. Representative Okay.
Okay. Rolling back time. Representative Lowen with reservations for HB 662.
Great.
Your recommendation is still adopted, Chair.
Okay. Yeah, I lost my place now. Okay, House Bill 199, election proclamations. On this, the chair is going to recommend that we adopt amendments recommended by Common Cause, that the days each voter center and place of deposit is open with their opening and closing hours of operation, and to the location of each voter center and place of deposit be included in the proclamations by the clerks. Also, technical amendments needed for clarity, consistency, and style. Members, any questions or comments? Okay, if not, Vice Chair, House Draft 1.
Chair's recommendation is to pass HB 199 with amendments noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you very much. House Bill 248, marriages, civil union solemnizations. The chair is going to recommend that we add language consideration of a licensing fee to be taken of $40. And that be it. Any questions or comments? Representative Ward.
Chair, I think the bill is probably necessary, but the way that it's so broadly worded, when the Department of Health said, yeah, it looks like the Boy Scouts would, they would qualify to do this. And I thought, well, the Chamber of Commerce and other entrepreneurs will get into it. And then marriage kind of loses more of whatever otherwise a ceremony would be.
So
I think it's got to be tightened up.
Should I raise the fee to $100?
You know, 200. Go ahead. Anyways, that's my reservation.
Okay, reservations. Representative Takumi.
So that $40 fee is paid by members of the religious community as well? It's a standard fee.
It would be a standard fee.
Well, anybody who performs a marriage, clergy and otherwise?
I believe so.
Yes.
Okay, and then the $40, it's an annual fee or per ceremony? What's
Per ceremony.
Okay, thank you. $40 a ceremony.
Marriages are expensive. I mean,
You gotta put up when you get married.
Chair.
And you gotta pay the we put that in for discussion purposes. Okay, members, any other questions?
Chair,
Representative Presti.
I'd like a ruling on a potential conflict. My spouse is an officiant for weddings. I frankly don't know how this might affect her, but I thought I should say that.
Yeah, no conflict, Representative.
Thank you, Chair. I'm an aye.
Any other questions or comments? Seeing none, Vice Chair, House Draft 1.
Okay, Chair's recommendation is to pass HB 248 with amendments, noting the previously excused members and the with reservations vote by Representative Ward. Any other members voting with reservations? Any other members voting no? Chair, your recommendation is adopted.
Okay, House Bill 31, firearms responsibility storage with respect to minors. Members, Chair's intention is to pass this as is. Members, any questions or comments?
Sure.
Representative Kobayashi.
Thank you, Chair. So one issue I have with this is just that we're saying that you're required to do a safe storage of firearms. We're changing that from 16 to 18. Yet you can operate probably the most dangerous thing we have here on the island, a motor vehicle, by yourself at 16. At 17, I believe you can join the military at 17, giving you access to machine guns, grenades, RPGs, whatever there's out there. But at 18, we're saying until 18, you're required to do safe storage of firearms. So just our definition of what you're safe to do at what age seems wildly inconsistent. I'm with reservations on this.
Okay. Okay, well, Representative, even cars have keys. Okay, Representative Ward.
Chair, no vote for me, thank you.
Okay, no vote, thank you. Members, Representative Tokioka.
We're going to use
No vote?
Kobayashi's speech and vote no.
Okay. All right.
I'm just gonna go with reservations
Joby?
because, I'm sorry, yeah, don't go with WR just because it's a clean date and there's no chance to look at the issues raised in conference. So WR, thanks.
Okay. Members, any other questions or comments? Seeing none, Vice Chair.
Chair's recommendation is to pass HB 31 as is, noting the reservations of Representative Kobayashi and McKelvey and the no votes of Representatives Tokioka and Ward and the previously excused members. Any other members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you. Okay, members, House Bill 341, Administrative Procedures. The chair would like to defer this to the next meeting. Defer decision making to the next meeting. House Bill 357. Yes.
My understanding is when you defer, you have, if you're going to defer to a date certain, you have to set a date.
Defer to tomorrow.
Let's say the time too, right? See what you started.
Okay, statute of limitations, regulatory taking, constitutional claim. The chair notes that the AG brings 567 into line with other laws and the 2-year regulatory taking actions against the state, including the claims brought against Article 1, Section 20 of the state constitution shall be commenced within 2 years after cause of incident. So what we want to do is on page 1, lines 2 and 3, and page 2, lines 4 and 5, actually put in regulatory taking into the language of the bill. Members, any questions or comments? Or inverse condemnation is the term instead of regulatory taking. Okay, sorry for that. Members, any questions or comments? Seeing none, Vice Chair, House Sheriff 1.
The Chair's recommendation is to pass HB 357 with amendments, noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you. House Bill 818 relate to criminal trespass on state lands. Vice Chair for the recommendation.
Yeah, Vice Chair recommends the inclusion of but not limited to make it clear per the prosecutor's office's testimony that the evidence is not limited to the video recordings or photos.
Okay, members, any questions or comments?
No comment.
Representative Kobayashi.
Thank you, Chair. In the last couple of years, we've seen more public outcry about various projects that they have determined are not in the public interest for one reason or another. We've also seen in the last really 10 months efforts to limit that dissent by citing social distancing and other lockdown related issues. There's really no justification for us to be making it more difficult to protest or dissent. We need to make it easier for people to express any dissent to what we're doing, particularly with respect to public lands. I'm a no vote on this.
Okay, thank you. Members, any other questions or comments?
Yeah, I do have a comment, Chair.
Representative Matayoshi.
Yeah, this bill does not affect protesting at all. And I recognize the testimony from one of the people who submitted written testimony that regards it. He seems to have missed the point, though. This is only regarding the admission of photographs or video that have been taken by another individual to be introduced into evidence. Actually, the real point of it is to make sure that police know that they can use this when issuing citations, which is unclear right now. So that's the point. It has nothing to do with protests. I just want to make that clear.
Okay. Representative Nakamura.
Yeah, I'm just going to probably do a WR on this, both the prosecutor and the public defender, raised some concerns. So I don't understand what it's trying to achieve.
Okay, thank you. Anyone? Representative McKelvey.
Is this, do the amendments include effective date, or is it going to go out clean?
I did not make any amendments to the date.
No, but the prosecutor's office concerns were addressed in the amendments.
So it's going out clean. Is that what it is? So it's going over clean? It's
Yes.
going out of the committee clean?
Yes.
Oh, as amended, yeah.
Members, any questions or comments? Seeing none, Vice Chair, House Draft 1.
Okay, Chair's recommendation is to pass HB 818 with amendments, noting the previously excused members and the with reservations of Representative Nakamura and the no vote of Representative Kobayashi. Any members voting with reservations? Okay, Representative Takumi, Representative Tokioka.
Yeah. Me too.
Okay, so Representative McKelvey and Lowen. Any members voting no? Besides Representative Kobayashi. All right, Chair, your recommendation is adopted.
Okay, thank you very much. House Bill 542 related to uniform controlled substances. Chair's recommendation is that we pass this out as is. Members, any questions or comments?
Chair? Did the
Representative
chair,
Ward?
did the chair consider Dr. Otto's amendment?
Yes, and I informed the doctor that he's making a major change to the bill without any notice or hearing. So normally if we were going to introduce substantive changes like that, we would put a House Draft 1 out.
Fair enough. Thank you.
Members, any other questions or comments? Okay, seeing none, Vice Chair, as is.
All right, Chair's recommendation is to pass HB 542 as is, noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, House Bill 1138 relating to abuse. Chair's Chair would like to defer this one day to tomorrow. House Bill 1090 related to child passenger restraints. Chair's recommendations that we pass this out as is. Members, any questions or comments? Seeing none, Vice Chair, as is.
Yeah, Chair's recommendation is to pass HB 1090 as is, noting the previously excused member. Any other members voting? Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you. House Bill 1366 relating to firearms. Chair's recommendation is to defer this one day to tomorrow. House Bill 1117 relating to vacancies. Chair's recommendation is that we pass this out as is. Members, any questions or comments? Seeing none, Vice Chair, as is.
Chair's recommendation is to pass HB 1117 as is, noting the previously excused member. Any members voting with reservations? Any members voting no?
No.
Right, Representative Tokioka. Any other members voting no? Right, Chair, your recommendation is adopted.
Okay.
Chair, question.
Yes.
Was HB 1366 deferred for one day?
Yes.
And 1090 also?
Yeah.
Okay, thank you.
No, not 1090.
Or just
Did
I
you
think
say
it
1090?
was 1138.
No, not 1090.
1138, Gene.
1138 and 1366.
Got it.
House Bill 1009, the structural harvesting of trees. In section 1, section 183-5, change the initial section from administrative penalties to general penalties. We'd like to add a subsection D for administrative penalties. And the section laying out a $10,000 fine or 3 times the market value of the value at the time of the taking of the tree product, determined by whatever fine is greater. Violation also applies if destroyed, damaged, or harvested, and restoration fee. They also, what we'd like to do is allow for civil action for people who violate the rule adopted for traffic infractions labeled in 291D, $100 for a first violation, $200 for a second violation, and $500 for a third violation. The criminal action against the party does not preclude the state from pursuing further civil actions against the party to recover for fines, assessments under this chapter. Section 2, HRS 183-18, criminal penalties setup, and Section 3, HRS 183, Section 4, refuse general penalties that were no longer needed. Okay. Members, any questions or comments? Seeing none, Vice Chair, House Draft 1.
All right, Chair's recommendation is to pass HB 1009 with amendments, noting the previously excused member, any member voting with reservations. Representative Ward with reservations. Any other members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you, members. So on the bills that deferred one day to tomorrow, it will be Wednesday, February 10th at 2 o'clock in this room. In room 325.
Last one, Chair, 1096.
You're going to defer that one too, but that's the last bill.
HB 1096, we also defer. Well, no, there were issues that the Attorney General had, right? Yeah, they wanted to rewrite the whole chapter. Okay. So we will defer this one day as well. Okay, thank you, members. We're adjourned.